Hi everyone, I'm Natalie Jensen. I'm a Managing Associate in the Shipping and Marine Insurance teams at Ince Dubai. We act for a number of bunker suppliers, and we thought it would be useful to pull together a brief snapshot of some of our recent experience and also provide our high-level advice in terms of action that can be taken to prevent disputes. The first piece of advice is know your terms. Now this might sound really obvious, but please do read and learn your terms. If you understand them and you know what steps need to be taken, then that really is the first piece of preventative advice in terms of being able to defend and prevent claims from the very outset. An obvious example is quantity disputes. So if, for example, your terms and conditions provide that the quantity of fuel delivered is to be determined by the gauge on the supplying vessel's fuel meter, and that is to be verified by the chief engineer on the receiving vessel, then it's really imperative that the chief engineer has the opportunity to verify the figures in order to ensure that the supply has been done in accordance with the clause, and also to prevent any disputes and defences from being made by the buyer. Another obvious example is time limitations. Now, to the extent that your terms and conditions provide for, say for example, buyers to submit claims within 7 days, then if you're aware of that and the buyer doesn't submit in time, then that is a complete defence to the claims that are submitted. We offer a service where we can review your terms and conditions for a fixed fee if they are subject to English and UAE law. And generally what we would do is review your terms, advise you in terms of any exposure that you may face, and also suggest amendments in line with applicable industry standards. The second piece of advice is make sure that you're as back-to-back as possible, and where that's not possible, make sure that you are aware of your exposure. Now what I mean by that is really make sure that the terms that you engage upon with your buyer are as similar as possible to the contract that you have with your physical supplier. The purpose of that really is to enable you to pass on any claims that you may have from the physical supplier or the buyer, and this really applies to the majority of the terms. So for example, the location of the sample that is binding should be the same under both contracts where possible. Clearly, if both contracts provide for different sampling locations, then you as a supplier are at risk in terms of any off-specification claims. Another obvious example is the applicable law and jurisdiction clauses, which for obvious reasons should ideally be the same in both contracts. To the extent that they aren't and a claim then materialises, you could find yourself in litigation in 2 different jurisdictions and subject to paying 2 separate sets of legal fees. Now, we appreciate that the legal ideals and the commercial realities are often entirely very different, and it may not be possible to ensure that you're on back-to-back terms in both contracts. If that is the case, then please do make sure that you're aware of the exposure that you face. The reason for that really is that it's important in factoring in the benefits in terms of doing the business as against the risks that you may face, but it also enables you to potentially seek insurance for any such risk. And most importantly, it means that you're forearmed in terms of any liability that you will face. The third piece of advice is know your counterparts and ensure that you're able to evidence the due diligence that you've undertaken on those. This is important because we've seen an increasing number of queries from banks for large-scale transactions where banks are really concerned about sanctions issues. We've seen payments be blocked, and that can obviously result in disruption to business, but it can also really impact commercial relationships. Given the current sanctions position, there's obviously clearly a labyrinth of sanctions position that you need to comply with, and it's really important that you do due diligence in respect of each element of the supply. So that can be the supplying vessel, the vessel interests, the requirements for payment in US dollars, and also the projects that the vessel is involved in, for example. If you carry out due diligence to start with, and then any concern is raised by the bank, provided that you're able to evidence the due diligence that you've undertaken, then you're really able to then quickly address the queries raised by the bank and ensure that payment proceeds very swiftly. Now, clearly, where preventative action is taken, then claims can still arise. If you have taken this type of action, though, you should be in the best place in terms of being able to defend the position and avoid liability. Now, this is really just a very brief snapshot in terms of some of the issues that we've seen and some of the steps that can be taken to prevent claims. Obviously, there are a number of issues where bunker supplies are involved, and we'd be happy to assist with any queries that you may have. Thanks very much for your time.